Hi, my name is Yogya Bhatia and I'm a legal intern at LEXIS and Company. Today I'll be talking about offense of adultery in India. Adultery is derived from a French word about that has evolved from the Latin verb adulterium means to corrupt. Adultery is defined as a consensual extramarital sexual relationship that is considered objectionable on social, religious, moral and earlier on the legal grounds as well. Though adultery is decriminalized, it still exists as a delinquent act as it violates social norms which an individual are believed to be followed. Since the last 158 years, it was treated as a crime, but after the verdict of Honorable Supreme Court in Joseph Shine vs. Union of India, adultery is decriminalized and remained merely a civil wrong rather than criminal offence. There were two major contentions for the decriminalization of adultery. They were this section provided husbands with the right to prosecute their wives adulterer, while wives were deprived to complain against the adulteries of their husbands. The section was ignorant on the matter of the adulterous act of the husband. Adultery according to religion. India is a country known for its unity and diversity. Our country is a secular country where sentiments of all religions are equally respected. Every religion follows its own views and objectives. However, in the matter of adultery, more or less every religion is highly critical. Different religions have different views on adultery, but the core view remains the same. In every religion, adultery is treated as a crime. However, the forms of punishment may vary among religions. It is treated as delinquent acts as it violates the religious sentiment of every religion. Since time immemorial, it is considered to be a sin not only on the religious or legal grounds but on the spiritual grounds as well. Traditional Hindu views regarding adultery are that it creates disorder in the society and degradation of family values. In Hinduism, marriage is a sacrament believed to be for seven consequent births, where both the spouses are supposed to be loyal to each other. They are believed not to have a sexual relationship other than the spouse. According to Islam, adultery, rape, and fornication, which are unlawful, are considered as zina. According to the Quran, zina is a huge crime for the what punishment are fixed by God. The punishment range from amputation of hands and crucifixion of public lashing to public stoning to death. In particular, to adultery, according to Quran, an adulterous person should be stoned to death. According to the Bible, adultery as a sin deserving death for both men and women. Adultery is treated as unethical and immoral and evil for the society. According to Buddhism, sexual intercourse outside wedlock is a sin that increases suffering. In Buddhism, adultery is a third of the five fundamental precepts that one must refrain. According to Judaism, which is one of the ancient religions, there is a provision of the death penalty for both adulterer and adulteress. Adultery according to law. In India, Section 497 of Indian Penal Code 1860 defines adultery as whoever has sexual intercourse with a person who is and whom he knows or has to reason to believe to be the wife of another man without the consent or convenience of that man. Such sexual intercourse not amounting to the offence of rape is guilty of the offence of adultery and shall be punished with imprisonment of either description for a term which may extend to 5 years or with fine or with both. In such a case, a wife shall not be punishable as an abettor. In 2018, Section 497 was struck down by Supreme Court. In the case Joseph Shine vs. Union of India, unanimously by the Constitutional Bench of 5 judges, comprising of Justice Deepak Mishra, Justice Ajay Manikar, and etc. It was also held that in the matter of any aggrieved spouse commits suicide based on the evidence should be treated as an abetment to suicide attracting Section 306 of IPC. However, though Section 497 got decriminalized, it continued to be treated as a valid ground for divorce according to the pronouncement of the then Chief Justice Deepak Mishra and Justice A.M. Khan Tvilakar. In the instant case, petitioner was Mr. Joseph Shine, a hotelier from Italy. Though he was personally unaffected by the law, his petition was accepted in the view of locus standi. That is, right or capacity to bring an action or to appear in court in public interest litigation cases with an objective of welfare of the society. The petitioner argued that the law deprives women of the fundamental rights to sexual autonomy, while government on the other hand argued it as an essential element to maintain the sanctity of marriage, although also recognized Section 497 as discriminatory against women and proposed to make the offence of adultery as gender neutral. In the case, it was held that criminalization had restricted the following rights of women: right to sexual autonomy, right to sexual expression, right to equality, right against discrimination. The then Chief Justice of India, Honorable Justice Deepak Mishra and A.M. Khalvikar, said that Section 497 of IPC creates differences on the basis of gender stereotypes that create a dent in dignity of women. They also stated that the emphasis on the consent of the husband that amounts to the subordination of women. Also, it violates Article 21 of the Constitution. According to them, adultery is not a crime, but they said that adultery is better to be left as a ground for divorce. Thus, they declared Section 497 of IPC unconstitutional and also declared Section 198 of CRPC in relation to the offence of adultery as unconstitutional. According to Justice Nariman, Section 497 of IPC, read with Section 198 of CRPC, is a violative of Article 14, 15, and 21 of the Constitution of India. Thank you.